This is a videotape deposition of Andrew Goilden in the matter of Wright et al. Versus Goilden et al. In the Circuit Court of Craighead County, Arkansas. This is case number CIV 98-394B as in boy. This deposition is being held at 511 Union Street, Jonesboro, Arkansas. Today's date is April 27, 2000. The time is 10:20 a.m. The court reporter's name is Michelle Barkley. The videotape specialist is Steve Grilletta. And counselors, would you introduce yourselves and state whom you're representing, beginning with Mr. Bobby McDaniel.
I'm Bobby McDaniel, along with Dustin McDaniel, are here on behalf of the plaintiffs.
I'm David Hodges. I'm here for Doug Goilden.
David Cahoon, appearing for Dennis and Pat Goilden.
Mike Roberts, Scott Johnson, Mitchell Scott Johnson.
I'm Bryce Marshall, and I represent Sporting Goods Properties, Inc., which was formerly known as Remington Arms, and with me is Karen Schwartz, also from Remington.
Val Price. I'm here making a limited appearance on behalf of Andrew Douglas Goilden, a minor.
Counsel, would you state any stipulations you'd like to get on the record, please?
Plaintiffs would like to stipulate that the deposition is taken pursuant to the Arkansas Rules of Civil Procedure upon the date, time, and place as set by order of this court, with objections as to the form of the questions to be made at the time contemporaneous, objections as to competency, relevancy, materiality, and other substantive objections being reserved, and it'll be up to the witness as to whether or not he chooses to read and sign. Any other stipulations?
I have a question to Mr. McDaniel. Are you saying under your local rules that the phrase object to the form of the question covers all possible objections under the Arkansas Rules of Evidence or Procedure?
Mr. Roberts, with all due respect, I don't think it's appropriate for me to give you legal advice as to how to object or to represent your client. If you have an objection that you feel needs to be raised, I have no objection to you stating it specifically. If you have an objection as to the form of the question, if you'll tell me what your objection is, I'll attempt to rephrase the question so as to make that objection no longer important. But if there's some objection you need to make, you're certainly free to do so. Objections as to substantive matters are reserved.
I don't understand what you mean by the word reserved. I'm not a local lawyer. I want to be very careful about what y'all mean by the local rules.
I think I've stated the rule, and as far as I think I can go.
David Hodges, let me state that my willingness to vary the rule, which is what we have to do by agreement, to reserve all objections except as the form of the question. That's what we would have to expressly agree to do in order to have the standard rule not apply. And the standard rule is that everybody makes an objection and no objections are reserved.
I'll then articulate my objections fully on the record to protect my client's interest.
All right, may the stipulation then be modified that any objection made or any objection to be made should be made contemporaneously or otherwise deemed waived. Is that the preference of counsel?
I'm not sure what the local practice is by the meaning phrase otherwise deemed. I'm not trying to quibble with y'all, but I don't take depositions here, and I'm not sure what the phrase otherwise deemed waived means in this county.
Let me just rephrase it to say this. I'm going to be asking questions. If any lawyer wants to object, regardless of what the stipulation stated, the other lawyers have not agreed to the stipulation, so I intend to ask questions, and lawyers may object when and as and under such circumstances they deem appropriate.
Well, I'd prefer that we have a stipulation so that we don't all have to make an objection to it. And the stipulation is that we would reserve all objections except as the form of the question. And the form would be limited to leading question or a compound question, the form being not the substance of it, but the manner in which it is asked. And otherwise, we're going to have a much longer day if we don't all agree to reserve all objections except as to the form of the question.
I'm very willing to adopt that procedure, which is my home procedure, where if I say objection, that covers every possible substantive objection, and I'm still free to object to compound, leading, those types of questions, if I understand Mr. Hunt.
That's exactly what the proposed stipulation was, except that if you have an objection as to the form of the question, the objection should be stated as to what that objection is, so it can be cured by a follow-up question. Objection, for example, if he is asked to speculate on a matter about which he is not competent, you do not have to object to that, because that would be reserved and could be raised should that portion of the deposition attempt to be used.
Constitutional objections fall under which
Reserved.
prong?
Reserved.
Thank you.
That's our stipulation understanding. And as to the objection as to the form, Bobby is saying you need to tell him specifically the objection is. You can't just say object to the form. You got to be specific, as I understand it, say I object to the form because it's a compound question or something like that.
And all other objections, including constitutional,
Are reserved.
are under the phrase object to the form.
And that would include the proceedings that we just had in court before Judge Burnett with all of the motions and so forth. Those are all reserved, not have to be made contemporaneously with the time of this deposition.
That's
I would point out that if you are going to instruct a witness not to answer the deposition on the basis of privilege, that under our rules, as I interpret it, must be asserted in the basis of the privilege stated and with specificity as to privilege. Okay, may we proceed?
The stipulations as discussed and agreed to among all parties are so noted, and would the court reporter please swear in the witness?
Before we do, I'd ask for one other agreement, and that is if any defendant objects, that all are considered to join in that objection, unless they don't want to, in which then they can state that. And that will help us move time and not have everybody me tooing throughout the deposition.
That's agreeable.
Agreeable.
Again, that stipulation is noted, and would you please swear the witness?
May I have you raise your right hand? Sir, do you solemnly swear or affirm the testimony you're about to give in this cause will be the truth, the whole truth, nothing but the truth?
I do.
Would you state your name, please?
Andrew Goilden.
Mr. Goilden, you're going to have to speak up loudly, please, so that everyone here can hear you. My name is Bobby McDaniel. I'm going to ask you questions. This is a deposition. A deposition is your testimony under oath where you're sworn to tell the truth. Do you understand what swearing to tell the truth is?
Yes, sir.
Do you understand there are consequences, adverse consequences, even potential criminal penalties if you swear to false statements, including perjury?
Yes, sir.
Okay. Are you under any medication today that would affect your ability to understand questions or to respond to them?
No, sir.
Have you been subjected to any physical abuse or difficulties so that you cannot understand or comprehend questions?
No, sir.
Do you consider yourself at this point able to understand the questions I've asked you so far and to answer them?
Yes, sir.
If at any time during my questioning, if I ask you a question and you do not understand it, will you let me know so that we can try to communicate effectively?
Yes, sir.
If during the course of the deposition you give an answer and you later realize that answer is not correct or is incomplete or needs to be changed in any format, I will tell you that if you will let me know, I will let you go back and add to an answer you've previously given. Is that understandable?
Yes, sir.
Is that agreeable?
Can I just interrupt one more thing? Do I understand that the local rules do not waive signature on a deposition?
The witness can waive signature if he chooses.
That the local rules do not normally waive signature. I apologize for bringing it up late, but just something I thought of.
The witness has the choice
Okay,
at
thank
the
you.
end of the deposition.
My apologies.
No problem. Okay. So, Mr. Goilden, then we're understanding each other that I'm going to ask you questions and expect you to give sworn, truthful answers to the question asked, and you will do so. Is that agreeable?
Yes, sir.
Okay. Tell me your full name.
Andrew Douglas Goilden.
What is your date of birth?
5/25/86
Where were you born and raised?
in Jonesboro.
How old are you now?
13.
13?
Yes, sir.
And where do you currently reside or stay?
In Alexander Youth Service.
When did you first go to Alexander Youth Services?
I can't remember the day.
Okay. Who are your parents?
Dennis and Pat Gold.
Dennis and Pat Goilden? You
Yes,
can't
sir.
nod your head, you have to answer out loud.
Yes, sir.
And are they present today?
Yes, sir.
Have you had an opportunity to talk with them today?
No, sir.
Who are your grandparents?
Dennis and Jackie Golden.
I'm sorry?
Dennis and Jackie Golden.
Dennis and Jackie Goilden?
Yes, sir.
Who is Douglas Goilden?
My grandfather.
Okay. Is he one and the same as Dennis? I ask you, who were your grandparents? Who are your grandparents?
Doug Golden and Jackie Golden.
Okay. Where did you live prior to March 1998? Where did you live before the shooting incident at Westside?
In Jonesboro.
What was your street address?
I can't remember.
Where was it?
It's,
You don't know where you lived?
I know, but I just don't know the street number, address.
Do you know what street name it was?
No, sir.
No?
No, sir.
What was your, where did you live close to? Did you live close to Westside School?
Kinda.
Was there some building, store, service station, road that you can tell me that where your home was close to?
It was close to the church, I remember that.
Close to what church?
I'm not sure the name.
Okay. How did you get to school in the mornings?
On the bus.
On the school bus? You have to say yes,
Yes,
or no.
sir.
What school bus did you ride?
I can't remember.
Do you know who the school bus driver was on your regular route in March of 1998?
I can't remember.
Was it a man or a woman as your usual bus driver?
A woman.
What grade were you in March of 1998?
6th grade.
Where did you go to school for prior years? Had you always gone to Westside?
Yes, sir.
Did you go to kindergarten?
Yes, sir.
Where did you go to kindergarten at Westside?
Yes, sir.
Prior to kindergarten, did you attend any nursery school or any sort of a pre-kindergarten school?
I can't remember.
I want to ask you some questions concerning your prior experiences in life and your background. Have you ever driven an automobile before? A car or a pickup truck? Either with or without an adult present. That's a yes or no question.
my client refuses to answer that question.
Well, wait a minute, Mr. Price, he hadn't
And is
refused to answer.
invoking his Fifth Amendment right
Wait a
against
minute.
self-incrimination.
And Mr. Price, your client did not refuse to answer any question. He didn't answer.
I'd like to confer with my client.
I refuse to answer that question.
On what grounds?
Fifth Amendment.
Prior to January 1 of 1998, had you ever driven an automobile either with or without an adult present? Yes or no?
I'd like to confer with my client.
I refuse to answer that question.
I think we need to adjourn the deposition and bring the judge in.
We're going to adjourn the
Wait,
deposition.
wait, wait.
Excuse me.
just walked in.
We are not going to adjourn the deposition. We'll continue.
Your Honor, the question was asked, have you ever driven an automobile either with or without an adult present prior to January 1, 1998? Mr. Price instructed him to invoke the Fifth Amendment. We think that's an appropriate question to be asked.
Any questions concerning driving may impact upon the events that took place on the day in question, and therefore it is relevant and subject to the Fifth Amendment. My client invokes that right.
Are you saying that he might subject himself to some penalty for a driving violation by not being a licensed driver? Is that what you're...
No, sir, I'm saying that the factor of whether or not he was driving on the date in question may impact upon whether or not he's driven a car previously, and
I thought the question was whether or not he'd ever driven a vehicle prior to that time.
Yes, sir.
Alone or with supervision.
Yes, sir.
I think that's an appropriate question. I don't see how it could touch any possible thing that would incriminate him except on a traffic violation, perhaps.
Because one of the issues is whether or not he was driving on the day in question, and therefore it would
That's
relate
not
to...
what he asked. He asked whether he had driven a car alone or with an adult supervision prior to that.
Prior to January 1, 1998.
I think that's an appropriate question. In a civil case, I don't see where it affects his...
Please answer the question.
No, sir.
Prior to March 24th, the date of the shooting at Westside School, before March 24, 1998, between January 1 and March 24, had you ever driven an automobile either in the presence of an adult, alone, or in the presence of anyone else?
No, sir.
Okay. On March 24, 1998, did you drive an automobile?
I need to confer with my client now.
I refuse to answer that question.
When you instruct him so we can save time to refuse to answer, you're assuming that's on the Fifth Amendment?
Yes, on the Fifth Amendment, and he's refusing to answer any questions concerning any of the events that took place on March 24th.
Your Honor, I will reserve questioning on the date of March 24 till I get to a whole series of questions. I'll come back to that. All right. Okay. I want to ask you questions now concerning your experiences in watching others drive an automobile. Had you ridden in automobiles on numerous occasions prior to March 24, 1998?
Yes, sir.
Had you ridden in the front seat of automobiles before March 24, 1998?
Yes, sir.
Did your parents own an automobile?
Yes, sir.
Did they have an automobile that had an automatic transmission or a shift transmission, or do you know?
Automatic.
I want to talk now about your experience with guns. Prior to March 24, 1998, did you own a gun of any type?
I'd like to confer with my client.
I refuse to answer that question.
And specifically, my client refuses to answer that question or any questions concerning guns or firearms and is invoking his Fifth Amendment right against self-incrimination.
Mr. Price, while we're going to get the judge, I want to ask some other questions and see if you invoke the Fifth likewise.
All right.
Mr. Goilden, at any time in your life before March 24, 1998, had you ever been given any instructions on how to fire a weapon, a firearm.
He invokes the Fifth. He invokes the Fifth Amendment.
All right.
For the
Mr.
same
Price, at
reason.
this point, I'll agree that you just...
Continuing the objection for the same.
All right. Prior to March 24, 1998, had you ever been hunting with a firearm?
He invokes the Fifth.
Prior to March 24, 1998, had you ever been present, whether you had a gun or not, when someone else was hunting with a firearm?
He invokes the Fifth.
Had you ever played with guns prior to March 24, 1998?
He invokes the Fifth.
Prior to 1998, had you seen others use firearms for either target practicing or hunting when you yourself were not shooting the gun?
He invokes the Fifth.
I think we can stop here when we get the judge.
We're going to adjourn the deposition. The time is 10:41 a.m.
Don't answer that question.
I refuse to answer that question.
Your Honor, you're instructing the answer even in spite of the refusal?
Yes, I'm instructing him to answer, and the only remedy I've got is to hold him in contempt, which I've had somebody in his position tell me, what are you going to do, put me in jail?
Your Honor, we'll reserve a request for sanctions if we may, so the court may consider that.
Yes, I'm directing him to answer that question. It's not one that would normally incriminate one or subject one to criminal sanctions.
Prior to March 24, 1998, had you ever fired a firearm, rifle or pistol in your life?
Don't answer that question.
I refuse to answer that
Can
question.
we just have this as a continuing
Yes.
Yes.
sanction? All right. Mr. Goilden, prior to March 24, 1998, have you ever observed someone else shoot a firearm, be it rifle or pistol?
Don't answer that.
Prior to March 24, 1998, had you ever observed your grandfather, Douglas Goilden, shoot a rifle?
Refuses to answer that question.
Had you ever observed your grandfather, prior to March 24, 1998, retrieve a gun or rifle from a gun rack inside his home?
Refuses to answer that question.
What is the basis for the refusal of that?
Judge, the state's basis, the facts involved in this case are the allegations that my client seized guns from the grandfather's house. I think it's definitely pertinent. I think that it could be subject to incrimination. And
In what way? How would that incriminate him?
it could be a basis of the future criminal charges, Your Honor.
What future criminal?
The state could charge my client with burglary for breaking into his grandfather's house, for example.
Well, that wasn't the question. The question was whether or not he had ever observed a firearm being taken down or replaced, I believe. Or that's generally what the question was. From a gun rack. Are you saying that might subject him to some criminal sanctions because he had knowledge of the location of the gun rack? Is that what you're saying?
Yes, perhaps that could be it. There may be others.
All right.
Mr. Goilden.
I'm ordering him to answer the last series of questions, and we'll deal with that later.
Mr. Goilden, prior to March 24, 1998, had you ever held in your hands any gun owned by your grandfather, Douglas Goilden?
Refuses to answer that question.
Prior to January 1, 1998, had you ever held in your hands any gun owned by your grandfather, Douglas Goilden?
Refuse to answer that question.
Prior to January 1, 1998, had you ever seen Douglas Goilden retrieve a gun from his gun rack in his eating area of his home?
Refuse to answer that question.
Prior to January 1, 1998, had you ever observed any means used by your grandfather, Douglas Goilden, to attempt to secure guns in a gun rack by use of a cable and a lock?
Refuse to answer that question.
Prior to January 1, 1998, had you ever seen Douglas Goilden unlock or gain access to rifles in the gun lock with a cable lock system on it?
Refuse to answer that question.
The same question applicable to prior to March 24, 1998. At any time, had you seen your grandfather get a gun out of the gun rack by disengaging a padlock or removing a cable lock system?
Refuse to answer that question.
Had you ever had explained to you by your grandfather how to gain access to guns in the cabinet?
Refuse to answer that question.
Did you know where the key to the padlock on the cable lock system was stored?
Refuse to answer that question.
Had you ever seen your grandfather get the key and unlock the padlock to the cable lock system securing rifles in his eating area?
Refuse to answer that question.
Had you ever observed your grandfather fire a rifle or a shotgun at any time prior to March 24, 1998?
Refuse to answer that question.
Did you ever fire a rifle or a shotgun on the residential property or surrounding property of the home of Douglas Goilden?
Refuse to answer that question.
Did you ever fire a rifle from the patio area of the home of Douglas Goilden prior to March 24, 1998?
Refuse to answer that question.
Did you ever go target shooting with your grandfather, Douglas Goilden?
Refuse to answer that question.
Did you ever go target shooting with your parents or either of them?
Refuse to answer that question.
Did you ever receive any instruction on safe firearm usage from either your grandfather, Douglas Goilden, or either of your parents?
Refuse to answer that question.
Judge, I'm assuming your ruling is continuing that he should answer all of these questions up to now?
Most of them, yes. There'd be some that I probably wouldn't require him to answer of that last series.
Okay, well, if you can think of which one, tell me so we got a clear record, so we don't have to go back and play them back and get a ruling as to each one, because I was assuming that it was continuing unless you said otherwise.
Mr. Price, are you suggesting that last series of questions would subject him to potential charge of burglary for which he was not charged? Is that what you're saying?
Yes, sir, that's a potential charge.
Are those questions related to non-criminal conduct? That was consensual, voluntary conduct was the context and the framework of those
Most of them
questions.
are relating to what he observed his grandfather do, and to those questions, I certainly would order him to answer those. I don't think they subject him to any criminal responsibility.
As to the questions relating to instructions or guidance that he had received in the
Yes,
safety
those
study?
would be appropriate questions for him to answer. As far as questions about his knowledge as to how to open the locking system or where the key might be found, there might be some vague suggestion that by knowing that he could, and answering it, he could subject himself to possible charges of burglary. I'm not sure the state can even bring those charges at this point, though, Mr. Price. I think they might be barred.
Mr. Price, are you stating there's a good faith basis for believing that if he answers the question that he had seen Douglas Goilden gain access to the guns, that there's a good faith basis for believing that that would subject him to a potential criminal charge, and if so, what charge is brought by him? I think we're entitled to know that.
Yeah, I'm obviously not a prosecutor, state or federal prosecutor. My client may be subject to federal gun charges as well, and which also is another basis to object to any of these questions concerning any firearms.
What did he plead to in federal court if it wasn't gun charges? They had no jurisdiction on anything else that I'm aware of.
Judge, I have no direct knowledge of what may have taken place in federal court. I was not his attorney in federal court, and I've seen nothing in writing concerning Lee Allen Fowler. But I think there may be some federal gag order concerning that. I'm not sure.
Talking about gag orders, the newspapers outside wanting a copy of my written gag order, and I didn't call it a gag order. Do you have a copy of that order, Dustin?
I have a copy of Your Honor's amended order that you signed this morning. It's the only copy, as I haven't had the opportunity.
Let me have it now.
But now this
Was that filed under seal?
This order itself is filed under seal and contains all the information surrounding this morning's hearing, including those things that we all agreed should not be released.
If Your Honor, please, I have an objection to Mr. McDaniel's last question. We'll ask the court reporter to read it back, please. I'm not trying to be bothersome, but I think it's very that's what I assume. We're all struggling with it. Mr. McDaniel's last question.
To Mr. Goilden?
Yes.
is maybe his comment to Mr. Price, but it's in there.
My question to Mr. Well, off the record, my question to Mr. Price was essentially, can you state a good faith basis for what particular charge brought by whom and how this might subject him to jeopardy? Is that what you're?
Yes,
what you were-
let's let the court reporter get it, and then
Not that it concerns me about this specific question, but I hate to set a precedent that each time an attorney in future depositions or this deposition makes an objection, that would basically have a hearing on the objection. And you put the attorney then in a mode of giving testimony. I don't think that's what depositions should be. I mean, if the attorney makes an objection, the objection is noted, the judge rules, deposition goes on. There's no reason to have a mini hearing on each question. I hope we're not setting that precedent for all the depositions we got to take in this case.
That can be on the record.
We're off the record right now.
What is the question?
Have you found it yet? I don't know what they're asking.
Mr. McDaniel, are you stating there is a good faith basis for, hang on, it's stacked here. That if he answers the questions, he has something Mr. Goilden has stacked right here, access to the guns, that there is a good faith basis for, and that would subject him to a potential criminal charge. If so, what would the charge brought to him?
Why don't we fast forward and I'll re-ask it. Is that
do my guess and I'll object. I think I'll understand the question better.
We're back on the record now.
You ready? Mr. Price, you've interposed an objection of the Fifth Amendment instructing him not to answer the questions. My question is, can you state for the record a good faith basis for the objection, and what criminal charge is he facing, and what jeopardy does he face by answering the question?
Judge, I'm not sure, as I stated earlier, I'm not a prosecutor, I'm not sure exactly what charge he could be facing. The fact that we have an appeal pending, if the Supreme Court reverses his juvenile delinquency conviction, he's back in juvenile court again, and that the state can file additional charges if they want to, and that's an even more paramount reason that he's exercising the Fifth Amendment on this question.
If you are, please, I object to Mr. McDaniel's question, because I don't think Mr. McDaniel, as plaintiff's counsel, has standing to compel a defense lawyer to disclose the theory of his case and any communications between himself and his client. I think the court might have the power to compel the disclosure of that, but I don't want to set a precedent here. I certainly do not agree that Mr. McDaniel has any right to compel me to articulate a reason otherwise than to this court for my constitutional objection on behalf of my client. So I object
I
to
think
setting
that
the
probably
precedent.
was a question that the court asked in some fashion that Mr. McDaniel was repeating. I don't mind the Fifth Amendment being employed to defend him against some real, substantive, potential claim that could be made by the state or the federal government. But all this smoke and this innuendo, I mean, that to me is not a justification or a basis for the Fifth Amendment. It needs to be something specific that we can see and we can articulate and that people know exists, not just some guess or maybe. This is a civil case.
Yes, sir, but my client was charged with capital murder, 5 counts of capital murder, of which 2 key elements are the act and the intent. The questions Mr. McDaniel is asking could go to the intent, and by my client being forced to answer the questions in this civil matter today, if the Supreme Court reverses his conviction, that may impact upon his...
The prosecuting attorney is just 2 doors down. I'm going to go down there and confer with him about his position on these matters, and maybe we can resolve that.
Should we go off the record, or
Well, y'all can go right ahead and
we'll get into some other background areas that maybe are not objection when we come back to them? Mr. Goilden, we'll come back to questions about guns. Let me ask you about your home. Who all lived in your home prior to March 24 of 1998?
You want to answer that?
My dad and mom.
All right. And did you have any brothers and sisters?
Yes, sir.
Who were they?
Wesley McDermott.
What?
Wesley McDermott and Amy Bates.
Wesley McDermott and Amy Bates.
Yes, sir.
I'm going to have to ask you to speak up a little louder, if you will. Did they live with you there in the home with your parents?
No, sir.
Where did they live?
And my sister had her own house, and my brother was living with my grandma.
Did you have your own room, or did you share a room with someone else?
I had my own room.
Tell me about your room. How was it decorated? Did you have posters on the wall, for example?
No, sir.
Did you have any pictures on the wall?
I can't remember.
Did you have a stereo or any music playing device in your room?
Yes, sir.
Did you have, and I'm going to say records or recordings, meaning either a record, a CD, a tape, a cassette tape, or any means by which sound is recorded and then played? Did you have any recorded sound in your room?
Yes, sir.
What type of music did you listen to prior to March 1998?
Classic rock, sir.
Classic rock?
Yes, sir.
Can you give me the name of some of the artists whom you particularly favored? What groups or names of groups did you listen to?
All different kinds. All different kinds.
Can you remember any of them?
No, sir. Not right now.
Sorry?
Not right now, sir.
Did you have a videotape and television in your room?
Yes, sir.
Did you watch videotape movies in your room?
Yes, sir.
What type videotapes did you watch?
Action.
Action films?
Yes, sir.
Like what? Tell me some of the films you used to watch.
I can't really think any.
Are you telling me under your oath you can't remember one single movie that you watched in your room as an action film? I need an answer.
Yes, sir.
What is an action film? What do you call an action film?
Kind of like adventure and stuff.
Well, what is an adventure film, action film? What type of films are we talking about? Are you talking about films where war movies or Sylvester Stallone type movies? The guys that do the karate things? What kind of movies are you talking about?
Jack Leading.
Go ahead and answer. Sir, can you answer me?
No, sir.
Did you own some films, videotapes, or did you rent them?
Both, sir.
Huh?
Both.
Where did you rent videotapes from?
Blockbuster.
From Blockbuster? Anywhere else?
Yes. Hastings.
Hastings? Anywhere else?
Not that I can think of.
Did you have your own card to get videos at Blockbuster and Hastings, or would your parents or either one of them have to get them for you?
I didn't have a card or anything.
How did you get the films at Blockbuster and Hastings if you did not have a card?
Parents' room.
Your parents?
Yes, sir.
Okay. Did you listen to the radio?
Sometimes, sir.
What radio stations did you listen to?
I can't remember.
Can't remember. Did you have HBO or Cinemax in your room?
No, sir.
Did you have access to watch HBO or Cinemax in your home?
No, sir.
Did your home have a computer?
Yes, sir.
Huh?
Yes, sir.
Was the computer attached to the or connected to the internet?
Yes, sir.
Did you use the computer and the internet?
Sometimes.
When you use the internet, did you know how to get into the internet yourself?
No, sir.
So then anytime you watched the internet, was an adult present or worked on the internet?
Yes, sir.
And who would those adults have been?
My mother and father.
Did you ever rent any R-rated movies, action films where there was, say, people being shot, like war movies and things like that?
Yes, sir.
And did you watch a lot of action movies, war-type movies, or Commando, Green Beret, Navy SEAL, any of those elite fighting group movies? Did you watch some of those?
Yes, sir.
And did you watch in those movies people being shot and killed?
Yes, sir.
And did you watch in movies how, for increased accuracy, sometimes they would use telescopic sights?
Refuse to answer that question.
Do you refuse to answer?
Yes, sir.
Do you know what a telescopic sight is?
Refuse to answer that question.
In the movies that you watched, did you watch them alone, or did your parents watch these movies with you, these action films?
Parents watched them with me.
Did you ever watch them alone?
Not that I can remember.
Let's go to books. Did you have books in your room?
No, sir.
Did you ever get books from a library?
No, sir.
Were you ever bought books by your parents as gifts?
No, sir. Not that I can remember.
Did you watch videos at anyone else's home other than your own?
My grandparents.
All right. When you were at your grandparents', what type movies would you watch over there?
Same thing.
Adventure films,
Mm-hmm. Yes,
war
sir.
movies, that sort of thing?
Yes, sir. Yes, sir.
Do you remember the names of any of them?
No, sir.
Did you watch them alone or with them?
With them.
Okay. Were they R-rated movies as well because of the violence?
I think so, sir.
And did your grandparents live close to your parents?
Pretty close.
Did you ever walk from your home to your grandparents' home?
No, sir.
Were you always driven there one way or the other?
Yes, sir.
Okay. In the 6th grade, you started the 6th grade in August of 97, is that right? And then went to school until this incident occurred at Westside?
Yes.
Okay. During the school year of your 6th grade year, did you spend any time at your grandparents' home?
Yes, sir.
When you got out of school, where would you usually go in your after you got out of 6th grade in the afternoon?
To home. Home.
When you would get home after school, were you alone or was someone else at the home?
Alone, sir.
Alone?
Yes, sir.
And after school, did you ever go to your grandparents?
If she was there, she would come pick me up from school.
Sometimes your grandmother would pick you up at school and take you to her home?
Yes, sir.
All right. Out of the average 5-day school week, how many days on average would you go to your grandparents' home?
It wasn't every week,
Would you go at least one day every week, or some weeks you wouldn't go?
Some weeks I wouldn't go.
Would some weeks when you did go, would you go more than one day, like 2 or 3 days in a week?
Sometimes.
Okay. In the summertime, between school terms, did your mother and dad work?
Yes, sir.
What did your dad do in the summer before you started 6th grade? What was his job?
Postmaster.
Do you know what time he went to work and what time he got home? About?
Probably about 6, left about 6 or 7. And then got home about 4 or 5.
What did your mother do?
Postmaster.
And what were her hours of work?
She'd leave about 7, around 7.
And what time would she normally get home?
About 4 or 5.
And did that continue during the school year as well?
Yes, sir.
Did you catch a bus to school or were you taken to school in 6th grade?
I caught a bus
And where did you get on the bus? Where was the bus stop?
in front of my house.
Okay. How long was your bus ride to school? Were you on the bus for 10 minutes, a half an hour?
It wasn't very long.
Was your house one of the last stops before the school? Was the bus pretty well full by the time you got on?
Yes, sir.
In 6th grade, you came home and stayed alone in the afternoon if your grandmother didn't get you until your parents came home, correct?
Yes, sir.
Did sometimes friends come over to your house?
No, sir.
You were always alone.
Yes, sir.
In the 5th grade, the prior year, what did you do when you got out of school?
I went to a babysitter.
Who was the babysitter?
It was I forgot the name of the place. It was a daycare.
It was a daycare? Do you know the name at all?
No, sir.
Where was it?
It was just outside of Bono. Or it was just right in Bono.
Did your parents have a rule that you could not have any friends come over to your house?
Yes, sir.
Did you ever break that rule?
No, sir.
Did you ever get in trouble for not being where you were supposed to be?
No, sir.
Did you ever get kicked out of or removed from daycare in the 5th grade?
No, sir.
Did you stay in daycare throughout the entire school term of the 5th grade?
Yes. Pretty sure.
Did you start 6th grade staying at home or going to daycare?
Staying at home.
In 4th grade, were you in daycare after school?
Yes, sir.
Same one or a different one?
I can't remember. I think it was the same one, though.
In 3rd grade, did you go to daycare?
Yes, sir.
Same one or a different one?
I'm not real sure.
In 2nd grade after school, did you go to daycare or stay at home?
Daycare.
At the end of first grade, when you got out of school, did you go to daycare or stay at home?
Daycare.
Can you give me the name of any daycare you've ever stayed at?
Object to relevancy.
Go ahead.
No, sir.
Can you give me the names of any day school or daycare teachers or supervisors that you had?
No, sir.
Did you subscribe to any magazines, or did your family have magazines delivered to the home?
Yes.
What magazines were delivered to your home?
J.C. Penney.
What?
J.C. Penney, stuff
All
like
right.
that.
Any others?
None that I can think of.
Were there any hunting magazines in your home?
Yes, sir.
Were there any gun and ammo or magazines that featured guns or ammunition in your home?
Yes, sir.
You remember the names of any of those?
No, sir.
Did you ever look at those magazines?
Sometimes.
And did you read the magazines or look at the pictures of the guns and how they worked, or stories about guns?
Refuse to answer that question.
Did you ever print any material from the internet about guns?
No, sir.
Did you ever look at the internet and gain information about guns from the internet?
No, sir.
What kinds of sites on the internet did you visit when you were visiting internet sites?
I didn't get on the internet that much. I usually got on there for school stuff, for school reports.
When you got out of school and you came home alone, what did you do with your time from the time you got home until your parents came home from work later in the day?
Homework.
Homework?
And watch TV.
What were your academic achievements, or what were your grades in sixth grade? How had they been?
I think I had A's and B's. I'm not real sure. Can't remember.
What were your grades in fifth grade?
I can't remember.
Had you ever been expelled or suspended from school for any reason?
No, sir.
Had you ever been sent to the office for any reason?
Yes, sir.
In the sixth grade, were you ever sent to the office?
I can't remember.
All right. Well, just tell me all the times you can remember you were sent to the office and why.
Once in fourth grade for throwing paper on the bus.
Go what?
In fourth grade for throwing paper on the bus.
Okay. And after you were sent to the office, were your parents notified of that? Did they discuss that with you?
Yes, sir.
All right. Any other time you were sent to the office?
Not that I can remember.
In first grade, did you have any problems in school in first grade?
Not that I can remember.
Did you ever shoot another child with a pop gun and that had sand or dirt in the barrel?
Refuse to answer.
I refuse to answer.
Prior to January 1 of 1998, did you ever point at or shoot a pop gun or a toy gun with sand or dirt in the barrel at a girl's face?
Refuse to answer.
Did you know that if someone prior to March 24, 1998, did you know at that time if someone was shot with a high-powered rifle that it might kill them? Did you know that?
Refuse to answer that question.
Did you know that if you shot someone with a high-powered rifle prior to March 24, 1998, that it could inflict serious injury or death upon them?
Refuse to answer that question.
Whether you shot, let me rephrase the question this way. From your observations of television, magazines, books, videos, or personal observations, did you know that if someone were shot with a high-powered rifle, it might kill them?
Refuse to answer.
When you were in school, were any notes ever sent home to your parents concerning discipline?
Not that I can remember.
I want to go now to, very briefly, to the day of the events at the Westside School on March 24 of 1998.
If my clients will refuse to answer any questions concerning that day.
Your Honor, I take there's going to be a blanket one, so any question I would ask concerning where you went, what you did, who said what, who did what you observed, what, if any, events took place, you'd be instructed not to answer.
Yes, sir, that's
Mr.
correct.
Price, I need for you to clarify the reason you're directing them to invoke the Fifth. On one area I can understand, but as far as new charges being brought, they would have to be, by law, juvenile charges. And I just visited with the prosecutor, and I'm going to probably have him make some kind of statement on it in a minute. But Mr. Davis is on the way back from Little Rock, and Allen is not prepared to for them to do anything at all.
For the record, Alan Copeland, the deputy
Alan
prosecutor.
Copeland, the deputy prosecutor, I addressed the issue to him, and they're trying to resolve that from their office. And if they can, they'll tell us so. And if they can't, they'll indicate that. So that's. But the thing that gets me is that they can't bring any new charges in a juvenile form that would produce any more punishment than what was meted out. If they filed 10,000 charges, he got all he could possibly get.
I mean, I agree with the court that he received the maximum punishment under the juvenile delinquency
The
laws.
juvenile
But
court can't do any more than what it did, regardless of the number of additional charges. So I think it's kind of superfluous to say that the Fifth Amendment should be invoked to protect him against new charges. Now, on the other hand, if all of your objections are directed toward if he answers these questions, it goes to the issue of his competency and his ability to understand and articulate circumstances and events and his knowledge of them, then maybe they're well taken.
yes, sir, this last batch of questions dealt with the day in question.
Yes.
Your Honor,
As far as the central issue of the appeal, and the only issue that would even have any merit, I think, would be whether his competency.
Well, and also the insanity defense, which we've also raised.
I'm not sure an insanity defense is applicable in a civil case. I think you could probably call a person that was incompetent and question them. I don't know whether you'd want to or not, but as far as your potential claim for his competency, some of these questions might tend to show that because of his actions and his conduct that he knew and comprehended and understood what he was doing, so they might be well taken. Has a competency hearing been done? Has
No, sir, Judge
an
Will-
examination performed?
Yes,
Is
sir.
that available?
The judge refused to allow me to argue that at the juvenile court proceeding.
Well, I think in the juvenile proceeding, it certainly would be relevant as to any potential punishment that might be meted out. But as far as guilt or innocence in a juvenile proceeding, I don't think it would be relevant.
My arguments to the trial court at that time were that we could raise, competency and also insanity were in the criminal code, and those were defenses that would apply to a juvenile as well as an adult
But
defendant.
he's not going to be subjected to the adult criminal code ever.
But he's charged with the adult criminal code as a juvenile. He's charged with 5 counts of capital murder, 10 counts of battery. And my argument was the same criminal code that filed charges against him also contains defenses that he should be allowed to, and the state should not be allowed to charge him under the charges, but deny him the right to argue defenses under the same
I
code.
guess Judge Wilson ruled that because he was a status offender that didn't apply.
Yeah, that's essentially his ruling. Yes, sir.
If Your Honor, please, Mike Roberts on behalf of Mr. Johnson. Did I understand the court to say that you have spoken to the prosecutor about Mr. Goilden and about the potentiality of Mr. Goilden being indicted?
Well, that's not the way I put it to him. I went down and told him that a deposition was being taken and that the Fifth Amendment was being invoked, and that I wanted to know what the prosecutor's position would be on any statement that might be made relative to new charges, or any statement that might be made that would potentially be used to demonstrate competency or knowledge or intent?
I certainly would want the court to inquire about my client and the potentiality of further charges being brought against Mitchell Johnson.
Well,
I will be up next in this deposition and anticipate invoking the Fifth Amendment selectively, as is counsel presently. And if the prosecutor is presently willing to put on the record, Your Honor, that there'll be no more criminal charges against Mitchell Johnson, then that would speed up this deposition substantially.
well, I'm not sure he's ready to do that. We haven't gotten a hold of Mr. Davis, who is the elected prosecutor. I'm sure he'll want to make that decision, but I didn't limit it to either of the young men. I said that was an issue that was occurring in a civil case. What was their position? Of course, he wants to find out from his boss, which I would do. Your client's in a little bit different situation. He pled guilty to the juvenile proceedings, and there is no pending appeal.
I agree, Your Honor, it is different, but just for the sake of the record here, if the prosecutor is going to make a statement on the record, then I would like him to
I
consider...
don't know that he's going to do that. I just approached them with a problem that it was developing, and I'm not even sure that would solve it, but...
Judge, and I hate to interrupt, but can we get back to the deposition?
Yeah.
I'd just like to make his statement at this time, and all due respect to the court. If there are going to be any further ex parte communications with the Office of the Prosecuting Attorney, as it might affect the deposition in this case, I would like these parties to be a party to those communications.
I'm reporting to you, and before I left here, I told you I was going to walk down the hall and see what their position was. I thought that was, I'm not sure wasn't trying to do it behind anybody's back.
Judge, I'm being charged probably $3.50 a page for these ramblings of lawyers talking about things that aren't relevant to this deposition. I'd like to get on with my deposition.
You know,
How can it not be relevant to the deposition when the court is making rulings of questions that are being asked? These rulings are being made based, in some part, upon communications that are taking place outside this room.
Your Honor, may I proceed with my
to
deposition?
the court. Yes, you can proceed.
For the record, Your Honor, Mike Roberts on behalf of Mitchell Johnson, I have absolutely no objection to the court talking to the prosecutor whatsoever.
Mr. Goilden, in terms of events of March 24th, 1998, are you going to refuse to answer each and every question I ask of you about what occurred that date? Mr. Price, you're going to instruct him to answer.
Yes, sir, that's correct. He will refuse to answer.
Before March 24 of 1998, I want to ask you all contacts you had with Mitchell Johnson before that date, not related to the events of the shooting itself. You understand? In other words, I'm going to ask you, for example, did you know Mitchell Johnson? Yes or no? Did you know Mitchell Johnson?
Yes, sir.
How long had you known Mitchell Johnson?
I'm not sure, sir.
Well, did you know him in 5th grade?
Yes.
Did you know him in 4th grade?
No, sir.
Did you ever go to his house, or did he ever come to your house?
No, sir.
Did you all talk after school?
On the bus?
On the bus? Did you ride the same bus?
Yes, sir.
I'm going to ask you a question now that your lawyer may instruct you not to answer. This series of questions. Why did you shoot some of the people at the Westside school?
Refuse to answer this question.
Did you intend to hurt or kill any one individual specifically?
Refuse to answer the question.
Was anyone targeted by you specifically to kill or to injure?
Refuse to answer.
Did you and Mitchell Johnson at any time talk about who you were going to kill and why?
Refuse to answer.
Did you and Mitchell Johnson at any time talk about the circumstances by which this shooting incident would develop and take place?
Refuse to answer.
Were you in Kelly Taylor's daycare at any time?
Yes.
Why were you pulled out of Kelly Taylor's daycare? Do you know?
No, sir.
Do you know Becky Shannon, a school bus driver? Miss Shannon?
Yes, sir.
Was she your school bus driver for 6th grade?
Yes, sir.
Did you ever have any problems or difficulties with Miss Shannon?
No, sir.
Did Miss Shannon ever have to discipline you in any way while on the bus?
No, sir.
Do you know an individual by the name of Jonathan Woodard?
Yes, sir.
Was he a friend of yours?
Yes, sir.
How long had you known Jonathan Woodard?
I'm not real sure.
Was Jonathan Woodard an African American or a black boy or Caucasian?
He was black, sir.
Did he go to Westside School?
Yes, sir.
And I'm not talking about March 24 of 1998. I'm talking about on other occasions. Have you talked with him?
Yes, sir.
Did you consider him your friend?
Yes, sir.
Did you ever go to his house or he come to yours?
No, sir.
Did you ride the same bus?
No, sir.
Did you visit during recess or out in the halls or at lunch?
Yes, sir.
Did you tell Jonathan Woodard that you were going to shoot people at Westside School about 3 or 4 months before the shooting actually took place?
Refuse to answer the question.
Were you ever brought into the school in the presence of either Miss Render or anyone else to discuss a claim that you had told Mr. Woodard, Jonathan Woodard, that you were going to shoot someone?
Refuse to answer the question.
Who was your principal at Westside School?
Miss Kirtner.
Did you ever have a discussion with Mrs. Kirtner about a statement that you allegedly made to Jonathan Woodard about shooting someone?
Refuse to answer.
Did at any time Miss Kirtner order you to get counseling while you were a student at Westside School?
Refuse to answer.
Val, I don't see how that could be incriminating if he was ordered to get counseling. Are you seriously telling me that?
At this point.
Did you ever get any counseling from the time you were born up until the time of March 24 of 1998?
No, sir.
Did you ever go to a psychologist or a psychiatrist or a counselor of any type for therapy of any mental therapy of any sort?
No, sir.
To your knowledge, were your parents ever told to put you in counseling or take you to a therapist or get you some consultation concerning mental health at any time?
No, sir.
Were you ever placed on any medication relative to mental health?
No, sir.
Did you ever take a drug, for example, called Ritalin?
No, sir.
Did you ever take a drug called Prozac?
No, sir.
Did you ever take any prescription medication other than antibiotics when you had the flu or something like that?
No, sir.
Are you on any medications of any kind now?
No, sir.
When is the last time that you can remember that you took any prescription medications?
I can't remember.
At your grandparents' home, were you ever there when they got locked out of the home?
No, sir.
Where did they keep the hidden key to the house?
I don't know.
Sorry?
I don't know, sir.
What door would you usually enter when you went to visit your grandparents?
The back door.
The back door?
Yes, sir. The back door. Yes, sir.
Is that the door that comes in almost underground?
No, sir.
Where the back door back by the garage, is that the one you're talking about? By the carport?
Yes, sir.
Where you come in by the kitchen?
Yeah. Yes, sir.
Were you familiar with the other doors to the house? Did you know where they were?
Yes, sir.
Had you seen guns at your grandparents' house other than in the gun rack? Like on top of the refrigerator or in bedrooms?
Refuse to answer the question.
Were you familiar with a fence around your grandparents' home?
Yes, sir.
Had you played out there around the home since you were a small child?
Yes, sir.
And had you climbed over that fence to go play in the fields and stuff?
Yes, sir.
And had you played out in that field with your grandparents present?
Yes, sir.
Climbed the fence with your grandparents present?
Yes, sir.
Had you known that they had a shop building out by the house?
Yes, sir.
And they kept tools and equipment in the shop building?
Yes, sir.
Did you go to church prior to March 1998? Did you attend a church?
No, sir.
Had you ever attended church?
Yes, sir.
When's the last time before March of 1998 you remember attending any church?
I can't remember, sir.
Had you attended a church any time while you were in the 6th grade?
Not that I can remember.
Do you remember attending a church while you were in the 5th grade?
Can't remember, sir.
Do you remember what the denomination or type of church it was that you attended, if you ever remember?
Objection, relevancy.
Go ahead and answer.
Baptist.
Okay. Were you a member of any groups or clubs or organizations while you were in the 6th grade?
Like what?
Like anything. Anywhere from a school club to Boy Scouts to you name it. Any clubs or organizations of any kind.
Not.
No?
No, sir.
Have you ever told anyone prior to March 24 of 1998 that you were either in or affiliated with a gang?
No, sir.
Prior to March 24, 1998, had you ever used any illegal drugs?
No, sir.
Prior to March 24 of 1998, have you ever consumed alcoholic beverages?
No, sir.
Had you ever observed Mitchell Johnson use any illegal drugs of any kind, marijuana or any other drug?
No, sir.
Had you ever heard Mitchell Johnson say that he had used drugs such as marijuana?
Objection, hearsay. Objection, competency.
Go ahead and answer.
Yes, sir.
Yes?
Yes, sir.
What did Mitchell tell you that his drug use or what he had done with drugs? what did he
Objection,
say?
hearsay. I'm sorry, Mr. Daniel, I apologize.
No, go ahead.
No, go ahead and finish your sentence. Objection, hearsay. Objection, competency.
Go ahead and answer.
What was the question?
I can't hear you.
What was the
Repeat the
question?
Okay. What had Mitchell Johnson told you in the past about him using drugs, whether it's marijuana or anything else, or of alcohol?
Objection,
Tell me what he
hearsay.
told you.
Objection, hearsay, competency, foundation, leading.
Go ahead.
He said he had found some of his dad's marijuana. And he smoked it.
When did this conversation take place?
Objection, hearsay, competency, foundation, leading.
I can't remember.
Was it in 6th grade?
Objection, hearsay, competency, foundation, leading.
I think it was.
Okay, for these questions about this, I'll agree that's continuing
That's
objection.
a continuing objection.
Where were you when this conversation took place?
I can't remember.
Objection.
When he told you that he had found some of his dad's marijuana, what did he tell you he did with it?
Objection.
He said he had smoked it.
And did he tell you anything about the effect of the smoking of the marijuana? How it
Objection.
affected him?
Objection.
No, sir.
Did you ever smoke any marijuana?
No, sir.
Did you ever tell anyone that you had?
No, sir.
Did Mitchell Johnson brag to either you or anyone else that he had smoked marijuana other than the incident you told me about?
Objection, continuing objection.
Yes, sir.
Tell me about the other things Mitchell Johnson had said about use of marijuana.
Objection, continuing objection.
It was the same thing, but just other people.
Who are some of the other people he told about that?
Objection, continuing objection.
I agree that he continue
Oh.
as to all questions
Well,
related to marijuana.
Mr. McDaniel, I just want to make sure I make a good record.
Certainly, no problem.
Other of his friends.
Who?
Josh Brand.
Josh who?
Brand.
B-R-A-N-D. Okay, who else?
That's all I can think of.
I can't hear you.
That's all I can think of.
Okay. Who were your friends in 6th grade? Who did you consider your friends?
Jonathan Woodard.
Jonathan Woodard?
Jonathan Newman.
I can't hear you.
Jonathan Newman.
Jonathan Newman? Is that, how do you spell his last name?
I'm not real sure.
Okay. Who else?
Tristan Brewer.
Who?
Tristan Brewer.
Tristan Brewer?
Yes, sir.
Okay, you're going to have to speak up louder for us now. Go ahead. Who else were your friends?
That's really it.
So you only had 3 friends in 6th grade?
About.
Was Mitchell Johnson a friend?
Yes, sir.
Did you ever spend the night at any of your friends' homes in the 6th grade?
No, sir.
Did any of your friends ever spend the night at your home in 6th grade?
No, sir.
Who were Mitchell Johnson's friends?
Objection, continuing.
I'm not real sure.
Okay. When Mitchell Johnson told you about smoking the marijuana, and I realize the continuing objection, did he tell you how he smoked it? With a pipe or cigarette papers, or how he smoked it?
Objection, continuing.
He said he had cigarette papers.
So he had cigarette papers. Did he tell you who taught him how to roll a cigarette?
Objection, continuing.
Hmm.
Did he tell you how he knew how to roll a cigarette?
Objection, continuing.
No, sir.
Did he tell you how often he had smoked marijuana?
Objection, continuing.
No, sir.
Mr. Price, do I understand if I ask questions concerning his prior experience with gun training and from whom he had gun training, you're going to object to those?
Yes, sir.
You all, would this be an appropriate time to take a 5-minute break for the court reporter for counsel?
We're going to adjourn the deposition. The time is 11:42 a.m. We are resuming the deposition. The time is 12:33 p.m. Counselor?
Mr. Goilden, I want to pick up where we left off, and I'll vary some questions and come back to some things. Again, the same rules you realize you're under oath, right?
Yes, sir.
Prior to March 24 of 1998, had you ever killed any animals? It's a yes or no.
Yes. Yes, sir.
And what animals or types of animals had you killed in your life?
Squirrels.
Squirrels? Had you ever killed any cats?
No, sir.
Had you ever killed any animals other than squirrels?
Ducks.
Ducks?
Yes.
Any other animals?
No, sir.
Did you kill the ducks while they were sitting or flying?
Flying.
So then you would have shot them with a shotgun?
Yes, sir.
Refuse to answer that question.
As far as the squirrels were concerned, did you kill them with a stick or a rock?
No, sir.
Did you kill him with a gun?
Refuse to answer that question.
I want to go back to a question, and I want to make sure that you understand it. I asked you if in school you had gotten in trouble for pointing a little pop gun or toy gun at a girl and shooting her, and whether it was filled with sand or rocks or dirt. And you said you don't remember doing that. Is that right?
Refuse to answer.
I think he'd already answered that and discussed that. Well,
I'm not sure.
you remember that?
No, sir.
You remember going to the office and getting a paddling for doing that when you were in first grade, I believe it was?
I think.
You think you do remember that?
Mm-hmm. Yes,
You
sir.
have to speak up.
Yes, sir.
Okay. When you got the paddling, were your parents notified that you got the paddling?
Yes, sir.
Were your grandparents notified?
I'm not sure.
Did either your parents or grandparents come to the school and tell the school that you were not to be paddled again?
I don't remember.
Okay. You remember now what you got the paddling for, don't you?
Yes, sir.
All right, tell me why you got paddled at school.
For pointing a gun, a pop gun at a girl.
For pointing a pop gun at a girl?
Yes, sir.
Who was the girl?
I don't remember her name.
And you did more than point the pop gun at her, didn't you? You pulled the trigger and the air discharged some grass or sand or dirt or rocks at her face, didn't it?
Yes, sir.
Yes?
Yes, sir.
And had you ever pointed a gun at anyone else?
Refuse to answer.
You refuse to answer that?
Yes, sir.
Do you remember an incident in which a man had shot a deer and your dog went over by the deer? Do you remember that incident? And there was a confrontation of sorts. Do you remember that?
No, sir.
Do you remember an incident where your dog tried to get on a deer that a man had shot and he tried to take your dog away from the deer? You remember that?
No, sir.
Okay. Do you remember any incident in which you had a confrontation with a man about your dog?
No, sir.
Did you ever point a gun at a man relating to an incident involving your dog?
Refuse to answer.
Do you refuse to answer?
Yes, sir.
Okay. Did you ever go down to Wiener or in the Wiener area for recreational purposes?
Yes, sir.
And how frequently would you go to the Wiener area for recreational purposes?
Every now and then.
Every now and then? Was it more in the summer than in the winter?
No, it was winter.
It was what?
Winter.
Oh, you went more in the winter than the summer?
Yes, sir.
Okay. Did you engage in conduct at Wiener involving things such as throwing food at your mother, kicking at your mother, or yelling at your mother?
No, sir.
Okay. Do you know a Mrs. Kreider?
Yes, sir.
Who is Jan Kreider?
Terry Kreider's wife.
And where do you know them from, or what's your relationship with them?
They were my parents' friends.
And did they spend time around you and your parents?
Yes, sir.
And did you spend time with them down at Wiener?
Yes, sir.
Did you engage in shooting activities down at Wiener with them present?
Refuse to answer.
Okay. Do you know Mrs. McElvoy?
No,
Betty
sir.
McElroy?
No, sir.
Had you ever gone to any organized training on how to safely handle a firearm?
Refuse to answer.
Had you ever had any training in gun repair?
Refuse to answer.
Now, you suggest that could incriminate you?
Yes, sir.
Okay. Had you ever taken a gun apart?
Refuse to answer.
Do you know what a trigger lock is?
Refuse to answer.
His knowledge of knowing what a trigger lock is, you're instructing you not to answer.
Yes, sir.
We'll get back to that. Had you ever seen a trigger lock before?
Refuse to answer.
Is the judge around?
He's still, for your information, he's still at the,
He was still at lunch when I came back.
he was down to his cold drink though.
Had you ever received any other in-school suspensions or disciplines other than the paddling in first grade or anything else we've talked about?
No, sir, not that I can remember.
I want to ask you some questions and see if you remember any of these circumstances. Did you ever tell anyone you could get to or gain access to your family's weapons?
Refuse to answer.
Did you ever have difficulty getting other children to play with you?
No, sir.
To your knowledge, had any other children ever been told by their parents not to play with you?
Object by hearsay.
Go ahead and answer.
No, sir.
Did you own a knife back in 1998?
Refuse to answer.
Did you own a hunting knife in 1998?
Refuse to answer.
Did you have access to a hunting knife before March 24 of 1998?
Refuse to answer.
Did you ever wear a knife strapped to your leg?
Refuse to answer.
Did you ever wear a knife in public on your person?
Refuse to answer.
Did you wear camouflage as clothing to school on occasion?
Sometime.
Did you wear camouflage when you were not in school?
Sometime.
Your attorney has indicated that you are intending to, or have attempted to interpose a defense of insanity to the Westside shootings. Did you hear him say that?
Yes, sir.
Do you claim that you were insane on March 24, 1998?
Refuse to answer.
In March 1998, did you know who you were and where you were and what you were doing?
Refuse to answer.
On March 24 of 1998, did you know your name?
Yes, sir.
On March 24, 1998, did you know where you lived? Could you see your home and recognize it as yours from the street?
Yes, sir.
On March 24, 1998, did you know who your parents were?
Yes, sir.
March 24, 1998, did you know who your teachers were?
Yes, sir.
March 24, 1998, did you know where you went to school?
Yes, sir.
March 24, 1998, did you know Mitchell Johnson?
Yes, sir.
March 24, 1998, did you know individuals involved in this lawsuit?
Refuse to answer.
On March 24, 1998, did you know that it was wrong to kill somebody?
Refuse to answer.
March 24 of 1998, did you know that some things were okay to do and some things were not okay to do? Did you know that?
Refuse to answer.
March 24, 1998, were you aware of your surroundings, where you were, what day of the week it was, what time of day it was, and the circumstances that you were in?
Refuse to answer.
Have you ever had any psychiatric counseling up until today?
Refuse to answer.
I'm not asking what they said, I'm asking whether it's ever occurred. And I think I'm entitled to know that.
Refuse to answer.
While you've been in custody, who have you talked to about the Westside incident?
Objection.
And refuse to answer.
Have you talked to any lawyers besides Mr. Price?
Refuse to answer.
Has any lawyer represented you other than Mr. Price?
Refuse to answer.
Have you been charged in any federal criminal proceeding?
Refuse to
Objection.
answer.
Have you been sentenced to any sentence other than what has been imposed upon you from the Craighead County Juvenile Court?
Objection.
Refuse to answer.
To your knowledge, are any charges pending or about to be brought or you think might be brought against you?
Refuse to answer.
Have you ever been disciplined by your family?
Yes, sir.
What type of discipline has your family used upon you?
Like what? Like what?
Well, like spankings.
Yeah.
Being told to stay in your room.
Yes, sir.
Denial of privileges.
Yes, sir.
Being yelled at.
Not really.
Any other type of punishments that your parents had imposed upon you?
No, sir.
What about your grandparents? Did they ever impose any punishments on you?
No, sir.
What type of activities would you do that would get you spanked?
Cussing, stuff like that.
Cussing and what else?
That's about it.
How often would you get a spanking?
Not very often.
How often is that? Once a week, once a month, once a year? How often would you get a spanking?
Probably once or twice a year.
Who would spank you?
Dad, Mom.
What type of action would you engage in that would result in you being ordered to stay in your room as discipline?
Staying out too late or something like that.
Staying out too late?
Or staying on the phone too long.
Staying on the phone too long? What else?
That's
When you would stay out too late, what time would you come in that you would get in trouble so you'd have to stay in your room?
No, usually my parents give me like a time to be back, and then if I'm, over 30 minutes or something like that.
What about denial of privileges? What activities would you engage in for denial of privileges?
About the same thing.
When you got the spanking at school and you got home, did you get another spanking when you got home?
Yes, sir.
And so your parents definitely knew about the pop gun incident, shooting the child in the face, because they spanked you for it too?
Yes, sir.
Have you ever been the subject of any physical abuse?
No, sir.
You ever been the victim of any sexual abuse by anyone?
No, sir.
Inappropriate touching?
No, sir.
Have you ever abused anyone else, sexually or physically?
No, sir.
Have you ever shot at anyone else other than on March 24, 1998?
Refuse to answer.
Have you ever had any fights in your life?
Not that many.
You don't remember ever having any fights?
No, I said not that many.
Not that many? How many have you had?
Refuse to answer.
Have you ever had any prior contact with the police?
No, sir.
Have you ever set any fires?
No, sir.
Have you given any interviews to anyone about what happened or led up to what happened at the Westside School?
Refuse to answer.
To your knowledge, have any of your family members given any interviews as to what happened about the Westside School incident?
Refuse to answer and also hearsay. Both.
Val, help me out. How is it potentially incriminating him if he knows his parents gave him an interview? Help me out here.
Well, first of all, I think it would be hearsay. He would have no direct knowledge of his parents'
Discovery. You're not going to order not to answer it, are you?
Go ahead and answer that question.
Do you know about your parents giving any interviews?
No, sir.
Or your grandparents?
No, sir.
Do you agree that it would be wrong if you got paid any money for a story, a movie, or a book, or an interview, or anything related to this Westside incident? Do you agree that would be wrong?
Objection, leading, speculative.
Go ahead and answer.
Yes, sir.
Do you agree that you will not ever take any benefits, any money, or any profit from this incident?
Yes, sir.
Do you know of anyone who's been paid anything relating to this Westside incident?
No, sir.
Have you had a chance to talk to Mitchell Johnson from the time that you were placed in police custody up until today?
Refuse to answer.
How many times have you talked to Mitchell Johnson from the time you were placed in custody up until now?
Refuse to answer.
When you were a child, did you put on a puppet show that was videotaped for your school?
Yes, sir.
And your puppet show was done as part of a school project, is that correct?
Yes, sir.
Who helped you organize that or plan it or put it together? Your mom, your dad, or both?
Both.
Both of them did? And your puppet show, what did it involve? Tell me about it.
I had a puppet.
Well, what was the subject of the matter? What was the theme of the puppet show?
I can't really even remember now.
What was the title of it? Do you remember?
No, sir.
It involved the puppet using a gun and shooting, didn't it?
Not sure. I don't remember.
You don't remember the puppet holding a gun?
No.
What do do you remember about the puppet show?
Nothing really. I don't even remember it happening.
You what?
I don't remember.
Have you ever talked to Tom Firth, an attorney?
Objection.
No, sir.
When you were served with lawsuit papers when this case first started, what did you do with those papers? Did you give them to your mom and dad? What did you do with them?
I gave them to mom and dad.
What did they tell you they would do with them? Or what did they tell you they would do?
They said they'd put them up for him.
Whose class was the puppet show for?
I think it was Miss Wright's class.
And what, did you get a grade for that puppet show?
Yes.
You know what grade you got? Was the puppet show a quick draw scene? Did it have a quick draw scene with the puppet?
I don't remember.
I think we need to get the judge in on those questions that we spoke about earlier. Can you see if you can get the judge and go off the record for a moment?
We're going to adjourn for a moment. Time is 12:56 p.m.
No questions?
No questions.
Then may we consider the deposition temporarily adjourned until the judge returns, and start with Mr. Johnson. Is that agreeable?
Agreeable.
Yeah, Mitchell, you lose.
We are resuming the deposition. The time is 1:04 p.m. Counselor?
Your Honor, at this point, I had asked some questions earlier that you were not available, and I'd like to revisit those and get a ruling on them if I may.
For the record, I just went to lunch.
Oh, I know. Wasn't being critical. Mr. Goilden, do you know what a trigger lock is?
Refuse to answer.
I think we're entitled to have that answer, Your Honor.
And I could, there may be some type of federal gun charge that may be filed against my client.
Has anybody in this case gone to the federal prosecutors? I know you hadn't gone to the state prosecutors because one of you objected when I said I was going to. I can't believe that nobody has contacted them on that issue. Has that been done?
I have tried to make inquiry, Your Honor, and
The federal prosecutor, but the
Yes.
local prosecutor said nobody's even mentioned it to them. They were shocked that the matter was even being, the hearing was even being held.
that and the federal judge involved, and neither will even acknowledge that these two young men even exist in this world. They will not talk with you on any circumstances. There's other civil litigation involved in which the transcripts of the proceedings is being attempted to be obtained to no avail. So they just don't acknowledge that it exists.
Judge, irrespective of that, I think that these questions that I'm asking are questions we're entitled to have an answer on.
I think that question can easily be answered without risk of criminal sanctions being brought. So yes, I'd say that that's a question to answer. So I'm directing you to answer.
Go ahead and answer. Do you know what a trigger lock is?
Yes, sir.
You do know what a trigger lock is?
Yes, sir.
What is a trigger lock?
It's a lock to keep the trigger from being used.
And have you ever seen a trigger lock before?
Yes, sir.
When's the first time you remember ever seeing a trigger lock?
In a magazine, sir.
In a magazine? And would that have been when you were in 5th grade or 6th grade, or what grade would you have been in when you saw that?
I'm not sure, sir.
Okay. Obviously, it was certainly before March of 1998, wasn't it?
Yes, sir.
Okay. Do you know how to open a trigger lock if you don't have the key or the combination to it?
Refuse to answer.
I think we're entitled to that answer, Judge. There's not a contention that that was done in this case.
How to do something could go towards intent.
No, it's only asked as to what his knowledge of. Did you know how to get into a trigger lock if you didn't have a key or know the combination of the lock?
No, sir.
So if a trigger lock was on a gun, if you didn't have the key to the trigger lock or know the combination, you couldn't have used that gun if you'd wanted to, could you?
Objection calls for speculation.
Go ahead.
No, sir.
No, sir, is the answer, correct?
Yes, sir.
Okay. Had anyone ever shown you how to dismantle or get around or break into a trigger lock?
Refuse to answer.
Go ahead and answer.
My client refuses to answer that question.
Judge, I think we're entitled to
I
an
think
answer.
that's one I'd direct him to answer too. I don't see how it would subject him to any additional criminal charges or have to be used in any retrial of the juvenile hearing.
I'll phrase the question so it'll be easy for you, and somebody might object to leading, but so go ahead. Isn't it true that no one ever showed you how to break into or dismantle a trigger lock? Isn't that true?
Objection leading.
Objection leading and refuse to answer.
Isn't that true? Well, let me ask it the other way. Had anyone ever told you how to break into a trigger lock? Or to take one off if you didn't have the key or know the combination? Anyone ever shown you how to do that?
Object to hearsay and also refuse to answer.
Go ahead and answer. Do you understand my question?
Yes, sir.
Had anyone ever shown you how to break into a trigger lock if it was properly applied to a gun and you didn't know the combination or you didn't have a key? Anyone ever show you how to get that trigger lock off and go ahead and use the gun?
Object to hearsay, refuse to answer.
Objection leading.
Don't answer the question.
I think the court's already ordered you to answer.
My advice is still, by the court's ruling, don't answer the question.
What's your answer?
Don't answer.
You do not know how to get into a trigger lock if it was on a gun unless you had the key or know the combination. Isn't that true?
Refuse to answer.
Leading.
And leave.
Go ahead.
Don't answer.
Objection leading.
Judge, I think I'm entitled to an answer on that one.
I think you are too. I don't see where
The
there's
judge-
amendment protection against that kind of question.
The judge has ordered you to answer. Will you answer the question?
Don't answer the question.
Your Honor, we will reserve a motion for sanctions after we get the transcript and adjourn the deposition rather than conclude it, adjourn it for further proceedings after sanctions. Motion is presented.
Your Honor, we object to, for the record, I object to him adjourning the deposition. He can certainly have a right to have motions, but I'd ask that the termination be concluded, the deposition be concluded rather than adjourned.
Well, I guess his position would be the only way it can be concluded is if he gets answers to his questions. I'm also at a quandary of what kind of sanctions this court has available to it under these circumstances. I had a defendant, I think I mentioned it before, wants to tell me, what are you going to do? Put me in jail? He was in there for life, so I mean, what do you do? Can I sanction Mr. Price? I don't think I can do that either. Be in good faith, instructing his client not to answer the question.
I'm addressing the issue of the sanctions, Judge. I'm just saying that this deposition ought to be terminated as opposed to be adjourned.
pass the witness subject to the previous statement.
Could we have just a minute? Take just a second.
Sure.
If any of y'all researched...
Off the record.
Yeah, it doesn't have to be on the record.